Emily, welcome back. It's December 9th, 2025. We are finishing out the end of the year, and it's a blessing, just to see everything transpire. Thinking back from January of 2025, everybody stepping into 2025, was saying this is going to be my year. How many of you guys drop a one in the chat box? We're live here on YouTube, and we got Clarity tuned in right now as well, too. So I figured I might as well just go live as well. So Claire, if you got any questions throughout the Zoom, feel free to ask. Nobody else decided to show up, but it's amazing because everybody always wants to reach out to me at other times and ask questions in regards to credit, when my main focus has been on raising capital for our real estate deals. And, that's where I've been putting my focus. And if people want the time in the credit space, you guys will see me here every Tuesday at 7 p.m. Eastern time. The last two Tuesdays, I will say we haven't been here, as we've just been traveling and been on the move. But other than that, every Tuesday at 7 p.m. Eastern time, you guys will be seeing me. So with that being said, we'll hop right into today's call. And so today, I just wanted to give you guys a little bit of insight into more of the Fdcpa, because I see a lot of people are getting hit with lawsuits from debt collectors. I see a lot of people are getting hit with, just summons. They're being summoned by whether it's a debt collector or whether it's the actual creditor, right? They're actually being summoned to the courts. And so a lot of you guys are unaware of, just the steps to take, and you guys get into panic mode. How many of you guys drop a 3 in the chat box if you've been summoned? If you've been sued in the courts, by any one of these debt collectors or any one of these creditors, drop something in the chat box. Let's see who we got tuned in here on the stream. Okay, this will be a recording as well too, so all of you guys will be able to go through this. It's going to be a great breakdown of the Fdcpa, and then we'll dive a little bit into truth in lending as well too. But it's aware, I'm not going to beat a dead horse, as I've gone over this time and time again, that there's abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors, right? So we're well aware that this has been going on, this has been taking place. There's abundant evidence of such, and this isn't something that has just came about. This has been going on since the 1970s. This was passed, this act, in 1977 and beyond such as well too. Really since the whole creation of the Federal Reserve System, if we could think back to 1911 and then the creation of it in 1935, just from there, and understanding that the Federal Reserve System as a whole is a whole foreign entity, right? And so understanding such, this is the Fdcpa, that there's abundant evidence of abusive, deceptive, and unfair debt collection practices. Well, let's look into the abuse. Let's look into the deception, and let's look into the harassment. So we've got harassment. We've got false or misleading representation, harassment or abuse. False, misleading would be the deception, and then unfair practices as well too. So there's also a specific, section for each one of these codes or each one of those points within the congressional findings: deceptive, unfair, and abusive or harassive. All right, so let's come here to unfair practices, because this is what is going on time and time again, that I see. We can see here a debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. Or we understand that the collection of any amount. So how many of you guys have ever had a debt collector or a creditor tell you an amount? Well, that amount is an unfair practice, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. The acceptance by a debt collector from which any person of a check or other payment instrument post-dated by more than 5 days, unless such person is notified in writing How many of you guys have been notified in writing of the debt collector's intent to deposit such check or instruments not more than 10 nor less than 3 business days prior to such deposit? Then we've got I can't read that. The solicitation by a debt collector of any post-dated check or other post-dated payment instrument for the purpose of threatening or instituting criminal prosecution. All right, so this right here could be used if you guys have gotten that summons, have gotten that court case. Depositing or threaten to deposit any post-dated check or other post-dated payment instrument prior to the date on such check or instrument. So let's go ahead and just come here. Let's type this in here. Let's come down here to the AI debt terminator. Draft me up, or let's not even have it drafted up. Go through Paste or Monitor and find me court cases in accordance to 15 U.S.C. 1692F. As within 1692F, it states the unfair debt collection practices. I want you to go through and use specific cases where a consumer has won in federal court for the unfair practices of debt collectors and or a creditor. I then want you to help me draft up an affidavit that I can send to this debt collector through the CFPB, as well as personally sending them one through mail. I want you to draft up and find me 3 powerful and clear court cases where the consumer won using specifically 15 U.S.C. 1692F and explaining the claims that they used to help them win, as I will use those claims as well to help back how they've unfairly attempted to collect this alleged debt. Also, the biggest thing in general, family, is including your guys' story. How many of you guys are just throwing out different lawsuits or different laws at these companies? Drop a 5 in the chat box if you're actually explaining your story and what took place to you. So me, I didn't explain it. This is more generic. This can be more broad, but you got to explain the actual situation. And why? Because anybody can go and look up, and apply for a credit card under Claire Cooley. If they got access to your social, if they got access to your date of birth, your address, anybody can go and apply for something, and they can send it to their address. They can acquire that credit card, and they could use that credit card. Now, does that mean that Claire Cooley is obligated to paying something that she had no business, even receiving nor even knowing about as a whole? That's why identity theft is so huge, and that's why it's mentioned as well within the FCRA. So let's see what this drafts up. Pace or monitor, the pacer. Let's see what it does. Good question. It says, the statute 15 U.S.C. 1692F, the unfair practices provisions of the Fdcpa, is often invoked in consumer litigation. It prohibits unfair and unconscionable means to collect or attempt to collect any debt, and then lists certain and numerous examples: unauthorized fees, charges, improper handling of a debt, dated checks, non-judicial repossessions, threats without right to repossession, communication via postcard, misleading envelope. However, and this is critical for your purpose, I found very solid federal court wins under 15 U.S.C. 1692F alone, or primarily in public available case law. Why 1692F? Victories are rare and problematic for a template affidavit. This statutory language is broad, but courts often demand concrete, provable unfairness or misconduct. Generic assertions, the letter seemed unfair, often do not survive motions to dismiss. courts often threat. So you got to really explain yourself, as I mentioned as well too. So your guys' story is the biggest thing. Always explain your guys' story. Some cases allege 692F violations, but courts often dismiss them or rule in the favor of debt collectors. For example, Trichel versus Midland Credit Management. The plaintiff's alleged collection letters were misleading and unfair, but the court held that they lacked Article 3 standing because plaintiffs could not show actual reliance or damages. And so with everything that you guys do, it's always vital, to use Rule 12BC to state each claim. Let me see. Rights were infringed upon as they have gone through and improperly served me. From improper service, it's very clear that they've used unfair practices, and also they've invaded my privacy by coming to my place of abode without any attention, without putting me on attention or notice at all. Furthermore, the time was very inconvenient in pursuant to 15 U.S.C. 1692C. As I operate a business, this is where I'm explaining myself. With me operating my business, they've interfered with the time. And furthermore, from the service, you could look at that as well too through the declaration of service. I want you all to request, if you have been served, a declaration of service, which is going to be at the courts, and you guys can see whom they served. And 98% of the time, it wasn't the original person. And furthermore, they don't know whom is even whom. They don't know if you are actually Claire Cooley. They don't know if you are actually Ashley. They don't know who it is truly. And that's why also you never sign anything. And also, there's many people that have gone through and been deceived, and they've told that it was Amazon, right? And that Amazon was delivering this package, and to go through and sign this as an Amazon package, right? Your guys' signature is the most important thing, but that's also another form of deception and unfair debt collection practices. So just gave you guys a little bit more insight as to typically what does happen, and some documents to request from the courts if they are going through and filing or serving one at one's place of abode. Say they're coming over to your house and they served you or your daughter, right? If they serve your daughter, furthermore, that's improper service. And even further, you've got to be put on notice in writing that they're even going to be coming to your place of abode. So excellent. You're raising multiple powerful statutory and procedural arguments under the Fdcpa and federal rules of civil procedure. Let's break this down in a structured, comprehensive, multi-claim affidavit. So it's good that it's not just pulling up, random information or just giving you what it is that we're asking for. It's letting you know that, no, you actually have to show damages. You actually have to express and explain how your rights have been infringed upon. See, at the end of the day, it's not what you know, but it's what you guys can prove. You can know all of these consumer laws, but if you don't know how to prove any of them, it doesn't matter. And that's why really all you need is one violation. And from one violation alone, you guys can be able to get it removed, anything removed. Okay. So let's continue reading through here. Structure the affidavit. Okay, we'll frame the affidavit. Claim work 12B4. Insufficient process 12B5. Insufficient service of process. Wrong person served. Improper method. And then rule 12B6. Failure to state a claim upon which relief can be granted. So here's the affidavit. I, blank, a natural person, the consumer operating under the protections of the Fdcpa. submit this affidavit of truth and notice of violations regarding unlawful debt collection practices perpetrated by the debt collector or the law firm. Herein, the claimant, this affidavit outlines violations under the federal consumer protection statutes and procedural due process grounds. I reserve all rights, including the right to pursue civil damages and arbitration remedies. We went over how to file arbitration in the last live as well too. I highly recommend you guys check out the last live that we did on a Tuesday. I believe that was about 2 weeks ago, not this past Tuesday, or not the one before, but that one prior. I was not lawfully served as required under due process. Upon information and belief, the declaration of service court record confirms that I defendant was not personally served. Service was made upon an individual not known to be authorized to accept service on my behalf. No signed acknowledgement was ever provided, nor was notice delivered to me as required by law. In some instances, the process server allegedly used deceptive tactics, including impersonation, pretending to be an Amazon delivery agent to induce a third party to accept documents under false pretenses. These acts amount to fraud upon the court and violate my due process rights under the U.S. Constitution and procedural service standards. So, Sharita, blessings for tuning in. I was actually using the example that, was actually done to Sharita herself. They were actually served to her daughter as well. And, they were acting as Amazon, so she's not the only, she's one of very few that I've heard, the spotlight of them actually coming and pretending to be Amazon, but I've heard many different things along the lines. But that is something newer with them using Amazon that I've heard. So, they're very, what's the word, desperate, at the moment, a lot of these debt collectors. And, furthermore, what they'll do is, oftentimes they'll sell it to a third party debt collector as well, being, even an attorney's office. So people think, just because it's an attorney's office, oh, well, we got to be wary. Well, this is where we're going to come into the deception that we were just talking about earlier when we had seen, let me take you guys back here. All right, so we've got, let me take y'all back. So here in congressional findings, we've got there's abundant evidence of the use of abusive, deceptive. All right, so this is what we're going to get into now. We were just going over the unfair debt collection practices. Now we're going to get into deception, which is false or misleading representation. A debt collector may not use any false, deceptive, or misleading representation or means in the connection with the collection of any debt without the general application of the foregoing. The following conduct is a violation of the section. Number 1, the false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge, uniform. I've got a great video on this and where I'm breaking that down. What I want to lead you guys to, though, is the false representation or implication that any individual is an attorney or that any communication is from an attorney. See, many people don't even know what communication truly means as well. We talk a lot about this as well too within 15 U.S.C. 1692 CC. So within cease and desist, and I'll take you guys back here to 1692C as well, and then I'll go back to the term communication. But that's also why it's vital to understand the definitions within each subchapter, because it'll break this down to 1692A, which is the definition section for the Fdcpa. But you can also click on it, and if you're able to click on it, that means that Congress has defined that for you. They've defined it for you, the consumer. It means the conveying of information regarding a debt directly or indirectly to any person through any medium. Right? So if we think of any medium, or the conveying of information regarding any debt or directly or indirectly. to any person. We got to understand and remember the term person, through any medium, right? Any medium. So that can be through social media. That's communication, right? When they call you guys, that's also a form of communication. When they send you something through the mail, that's also another form of communication. Drop in the comment section some more forms of communication. Let's see if y'all can, touch on what I'm getting at. As a big form of communication that helps us a lot with getting off. Anybody in the comments? Let's see. Give me some more forms of communication. Non-violent communication. Okay. So another form of communication would be like one's consumer report. That's a form of communication as well. How many of you guys knew that? Let's come here to the stream. Anybody in the stream? Y'all don't want to be pretty, y'all a little shy on the stream or what? We got to get you guys in the Zoom call for you guys to be active and communicate. Or are you guys just fairly new to this and just taking it all in? Either one is all good. All right. So let's come back here to the AI debt terminator. So in some instances, where we are now. So that's the insufficient process in service. Ultimately, all of your guys is going to look different. I do ask that you guys all, that are being served, request that declaration of service. Request it. Then we've got here unfair or. So let me tell you guys that back. Actually, here I didn't finish going over what I was talking about. And we're actually going to get into that here in the next part as well too. About inconveniency within 15 U.S.C. 692C. So it states here, without the prior consent of the consumer, given directly to the debt collector, or the express permission of a court of a competent jurisdiction, a debt collector may not communicate with the consumer in the connection with collection of any debt at any unusual time, or a time or a place known or which should be known to be inconvenient to the consumer. When is it ever convenient for you guys to communicate with any of these companies? You guys got lives, you guys have got kids, you guys have got husbands and wives, and you guys have families and maybe a business, maybe some investment, that you guys are looking into or learning about, looking into. You guys got taxes that you guys are looking to learn how to deduct. You guys are looking to learn how to capitalize off of the 100% depreciation bill that Trump had passed. And you guys are like, I'm going to go ahead and invest in the real estate so I can get these tax advantages. As I'm aware now that taxes, that Trump had passed these bills and Trump had placed, these things in, place for real estate investors to capitalize off of, as he's one of the largest himself. So I'm going to go and I'm going to invest in some real estate as well. And we come down here and we got 692CC. If a consumer notifies the debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt, except to advise them that their efforts are being terminated, or to invoke specified remedies which are ordinarily invoked by such debt collector. Meaning, I'm going to be paying up remedy for the damages that were done, or I'm letting you know that I'm going to be, terminating and removing these accounts. Other than that, if a consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, and I can't tell you guys how many times I've simply came here to the CFPB, consumer complaint section, especially with debt collectors, and gotten so many different, accounts removed. Just expressing one, the term communication, and I demand that it be removed from my consumer report as that's a form of communication. And I've expressed how it's inconvenient to me as them communicating with me. A form of communication doesn't have to be a phone call. It can be on your consumer report. How is that inconvenient to you as a consumer? You've got to explain these things. As we just mentioned earlier on this call, you've got to be able to express how, everything that you're throwing out there as well too, or else these are just claims. You've got to back up each claim as well too. Because once again, it's not what you know, but it's what you can prove. So coming here, this deception amounts to, let's see, the claimant engaged in deceptive and unfair conduct, including attempting to serve legal documents through misrepresentation and approaching my place of abode without lawful notice or disclosure of identity. Courts have recognized that deception in service and coherence violates 1692F. These practices are unconscionable as they create confusion, invade privacy, and interference with the daily operations of my livelihood. The deception amounts to harassment, coercion, and the misuse of legal tools under the color of the debt collection. Then we'll get into 692C A1, contact at inconvenient time or place, operate a business and maintain specific work hours. The debt collector or their agent arrived at my residence or business location during business hours, interfering with my professional responsibilities. That could even then go into, how it's, let's see, let me show you guys. It could ruin one's reputation. It can be embarrassing and ruin one's reputation of them coming to your work, them coming to your place of abode. I wanted to make sure to throw that in there as well. Something else you guys can use. But coming here to the CFPB, we'll hop right back into the AI Debt Terminator and file your complaints. Start a new complaint. It's going to ask you for your personal information. It's going to ask you for the information on the business. If you guys need help finding the address, I recommend always using the address and the business profiling here at adr.org, and I'll show you guys where to go through and find their clauses. No worries. This is also going to be up on the YouTube, so you can go back and rewatch this one. We're streaming right now. There's only a couple of us today, so I figured I would just stream it. Knock out two birds in one stone. So here we go. So you go to the registry. You'll come here to view registered consumer arbitration clause. You can literally fill out anything. And let's say we're looking for Discover. Well, now I can come here to Discover Bank, and I can get their address here. Okay. If I want that arbitration agreement, they're right here as well. If there's any claim or disagreement, it states that it ought to be handled through arbitration. Or you ought to reach out to them and communicate with them. And if it's not handled, then you ought to take it through arbitration. Okay, therefore, let's come back to 692C. The FDCPA prohibits communication at any unusual time or place known to be inconvenient to the consumer. The claimant had no prior consent and no court order permitting such contact. Therefore, this action violates 692CA1, that demand acknowledgement and remedy. Then we've got 692D, harassment, oppression, or abuse. The conduct description, including deceptive service, showing up unannounced at my place of residence or business, and attempting to coerce or deceive me into attempting documents, constitutes harassment. The FDCPA explicitly prohibits conduct, the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. These actions have caused emotional distress, interrupted business operations, and constitute abuse. Then we've got an invasion of privacy. The claimant or their agents have engaged in willful intrusion by coming onto private property under false pretenses. They fail to notify or request entry in such unauthorized and deceptive conducts amounts to a civil tort claim for invasion of privacy. Relief granted that all claims can be dismissed under the federal rule of civil procedures 12B 4, 5, and 6, that all collection attempts cease immediately and that the claimant provide written confirmation of dismissal of the alleged claim, that any entries related to this matter be removed from my consumer report, and 4, that the compensation be rendered for the harm, time, and distress caused by the unlawful practices. So what we can do now, we're going to mail this off to the debt collector, file with the CFPB, and then file a motion to dismiss. Anytime you guys file a motion to dismiss, you always want, or anything in the courts, you always want to have 3 copies of what it is the docking, the docking area, because that you're going to mail. And so that's what I want to leave you guys with off today. I do want to see who has any questions. In like 10 minutes, we will be.
Have you asked some questions?
Mm-hmm.
Have they asked questions?
Yes.
So do you. Yes.
Your hands are cold, bro. Any questions? Any questions?
You know why?
Let me see. Let me pull up the share again. If you do have questions, now is your time to ask. Feel free. So some case law. McMillan versus Collection Professionals, Inc. Use of improper collection letters and deceptive tactics, which violated the FDCPA. Davis versus Midland Funding. False implication of court order and deceptive process service rejected as unfair. So just from them improperly serving you guys, we can get it. So don't even think that you need the rest of them. If they never even served you guys alone, like you, the natural person whom they're attempting to collect the debt from. And that's the thing, they have no way of really even knowing whom is whom. They could be looking and that's everything, when it comes to such. Because as I mentioned at the beginning of this call, what if one of you guys had somebody that went out and applied for credit cards online? Well, there's no way of them actually knowing who it was, and even when you guys go into the dealerships yourselves, when it's you naturally, there's no, in these further, and a couple months later, hey, stop covering my camera.
What's that for?
I'm on live on YouTube as well.
What's that for?
It's this one.
No, that one.
I'm on 2 platforms. He's over here covering the camera. And so, with that being said, we can insert in. Let's All right, we're back stream. We're gonna wrap it up straight on the YouTube. I'm just gonna add in the case law. I'm gonna end the Zoom just because it keeps it's too much outage for this garbage processor. We got the Intel processor. We need an M2. Really, we need the M5, but M2 will do. We need to upgrade soon, so upgrade coming soon. But check out the YouTube for the last couple minutes. That was really everything I wanted to touch on today. I didn't see any questions, so other than that, thank you for being here, Sharita. Clarity, she already dipped out when it disconnected, and my guy Sly. So we'll be doing these calls every Tuesday, same time, same link.
Every Tuesday, same time, 7 o'clock, right?
Yes.
Or Eastern?
Yes, ma'am. Same time.
Do I use the same link?
Yeah, same link every time.
Okay.
It's in the Discord
Awesome.
as well too. So check out the Discord. And have you been able to check it out and use any of the other resources in there to help you as well?
Oh yeah.
Okay, perfect.
That video sent, oh my goodness, that was so helpful.
Yes. Yeah, Brother Omar is a blessing. He's, I give credit and pay a lot of homage to him for all of the results I've been able to help people, have. And, so I'm super grateful for him and his teachings. And he's one of very few that I really stick with in terms of the teaching. So, there's a lot of rah-rah out there, but, what he's got, it works, and it's worked time and time again for me. So, I'm grateful.
Yeah.
Yes.
Amazing. Well, thank you.
Yes, of course. Do you have any questions?
I always look something new every time we talk.
Good. That's the goal. That's the objective. This is just the beginning. So let's keep going. Let's keep growing. On Thursday, we have another call at 10 Eastern time.
Okay.
So we'll be
Okay.
back here. Same link as well. And all the links will always be dropped in the Discord as well, too. So you can always check there as well.
Okay.
Yes.
Sounds good.
All righty, Sharita. You take care.
Okay.
Peace,
Have a
peace.
good
But not show her face.
She was driving.
Oh.
Yes,
You ready?
almost. So let me go ahead and insert in the case law studies into the affidavit, back in each claim. I want you to show how the consumers have been able to win in federal court using and exercising the exact claims and laws that we've used.
Listen to it. I want you to listen to it.
It doesn't do a sound back. It just types in what I'm looking for.
Did you hear my voice?
So here goes the supporting case law. Davis versus Midland. The court
What do you
held that
mean
the
this to?
deceptive or improper. I'm live on YouTube. Look, this is the stream. So when you're ready to stream, this is what we'll do it on. Let me see.
I'm not doing the cameras. Why is it not showing me?
There we go.
I'm not in the camera.
It's right here. When's it gonna be done? We're almost done. We got 4 people here right now. See?
One person already left.
Let's get some likes up on this video as well too.
Like and subscribe.
Like and subscribe. I have a client that they tried to serve, but they couldn't. He can see the lawsuit online through public records. How do you go about it without going to his county and accepting the service? I would send something back to them, just putting them on notice, just communicating with the company specifically. You don't even gotta, you don't even have to file anything to the courts. I would just file a letter right back directly to them, as improper service and, seeking remedy. And then also if they have that arbitration agreement with the original creditor, mentioning and, really letting them know that the next steps are going to be arbitration, and that you're going to be holding them accountable for such. And you've got evidence of such an improper service as you've never been served, but you see, their information has been used in the public courts and, without any awareness, so a little bit of what we've even touched on today as well. So hopefully that helps. So we'll just go over the case law, the supporting case law. Davis versus Midland, the court held that the deceptive or improper service that misleads the consumers may be a violation of the Fdcpa and grounds for dismissal. So even that one alone can, help you with your client. Freeman versus ABC Legal Services. Plaintiff alleges that he was properly served by the sewer service. Faker's a deceptive service. The court ruled that they constituted a plausible Fdcpa claim under 1692D and E. Then we got Courier versus First Resolution INV Corporation. The court found a violation where a debt collector served the wrong person and failed to properly investigate, which was considered unfair and deceptive. Then we got McMillan versus Collection Professions. A collection agency was found liable under 1692F for sending misleading letters and engaging in a conduct that lacked basic fairness in collection efforts. Then we've got Rex versus Chase Finn. The court acknowledgement that conducting a consumer during work hours without consent may constitute violation under 1692C. Leaving messages at times that disrupted work or violated a known inconvenience was found actionable under 692C. So this is for the inconvenience. Then for harassment or abuse, the court held that a single offensive or disruptive phone call at an inconvenient time may be sufficient for a violation under 1692D and C. Bank versus Pentagroup Financial LLC, 2009. WL, repeated unwanted contact and tactics that harassed the consumers were found to violate. And we've got an invasion of privacy, Thomas versus Consumer Adjustments, and Salermo versus Waters. And all of these as well, you guys can all go look more in depth into each one of these at pacermonitor.com. So I don't only want to just tell you guys this and bore you guys out with this information, but I want you all to go through and do your due diligence. Come here to Pacer, look into each one of those cases that I mentioned, and actually do your due diligence and look into the initial, response, look into the claims that these consumers used, use these arbitration agreements, hold these companies liable within their own agreements and their own terms, and file CFPB complaints, file Attorney General complaints, file FCC complaints, file SEC complaints. What bank is regulating, or what regulator is regulating that bank? Okay, well, file a complaint with them as a consumer, because I can assure you that every one of these regulators and any one of these corporations that governs and regulates these financial institutions and these debt collectors and these law firms, they all have a regulator and somewhere where you can file a consumer complaint, because you as a consumer is the most important piece of this whole puzzle, and we keep this whole operation going. And that's verbatim within 1601, as the misuse of one's credit directly impairs the efficiency of the banking system. Congress finds that economic stabilization would be enhanced, so the economy would be enhanced, and that the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof by consumers. The informed use of credit results from an awareness. So we've got to raise our awareness of the cost, therefore, by consumers. The more that we're aware, the stronger the economy will be, the more that these companies will be held liable. And, you guys are seeing a lot of these companies getting hit for hundreds of millions of dollars. That's nothing on, the grand scale of things in all reality. That's chump change for what they're getting from the month-to-month payments that they're getting from you guys of things that have already been credited, to, just all the deceptive practices that they use, to all the things that they use in the court systems to go ahead and just suck out and milk the system. At the end of the day, we are the ones who is originating all of this credit, and in return, they're giving us debt. How can I owe something that I created? Never made sense to me. Right? So thank you all for being here. It was Westlake Financial Services. I've done a CFPB and an FTC method. They've removed it from Experian and Equifax. TransUnion is the only one giving us a hard time. So with that being said as well, too, the fact that they've, I actually had something in regards to such with Westlake, a repossession years back that got me into this information. And so I would look to take them through arbitration. They definitely have an arbitration agreement. And the fact that you've got it removed already from Experian and Equifax, deletion is admission. That's them admitting, to them violating the law. And also the lawsuit is on portfolio recovery. That's clockwork with portfolio. I'd even like to file something, through the CFPB and the Attorney Generals. All right, fam. Any other questions before we head out of here? We'll be here every Tuesday live. I don't know too many other channels or too many other people that are out here providing this much insight and overload, giving you guys the exact step-by-step as to how you guys can take action on this as well. All right, family. Peace and love.